Thank you for joining us for another episode of Legal Angle with Emmanuel, the Law Olawale. I have a special guest today. She's a bankruptcy attorney. She also practices in other areas of the law. But then when it comes to bankruptcy, she is a queen. Her name is Laura Nesbitt. Welcome to the show, Laura.
Thank you very much. Thank you for having me. Happy to talk about the topic.
Sure. Can you tell us a little bit more about yourself?
Sure. So I currently practice in my own firm, which is the Nesbitt Law Firm, which I started in 2013 after leaving a small firm that was focused on criminal defense and bankruptcy. And I have a paralegal that helps me here. We're pretty busy with bankruptcies right now. We also do out of court workouts and settlements and other various municipal court and common pleas court actions and litigation. So that's mainly the focus of my practice right now.
Okay. You graduated from law school in 2017?
2007.
2007.
Yes.
What was your first job straight out of law school?
Let's see. My first job straight out of law school was mother. I walked the stage 8.5 months pregnant with my first child. So we took the bar, my husband and I both, about when she was 4 weeks old. And my husband had a job, and I decided to stay at home with my baby daughter and do that and nurture her for about a year. So that was my first job. And then I went on to personal injury law, where we were plaintiff's counsel.
Okay. I believe your husband is also an attorney.
He is. Yes, he still does criminal defense. He started off at the public defender's office and then went into private practice where he is now.
Okay. What's the conversation like at the dinner table?
We stay as far away from the law as possible, but it creeps in. I will tell you, my 14-year-old daughter is very much of a not argumentative person, but she sees different angles of things that she can sneak into an argument that makes a point that we didn't think about. And it's like, oh, you're quite
Hmm.
intuitive for a little 14-year-old gal. So I think it's rubbed off on her for sure.
She's loyally.
Yes.
So, what inspired you to become a lawyer?
I just always wanted to feel like I was helping others. And I wanted to be able to use my academic skills in a way that encompassed that. And I was undecided in undergrad between whether I wanted to become a medical doctor or a lawyer. And just I was led down more of the path of interest of psychology and criminal justice. Those became my major and minor in undergrad. And so I felt like it matched up with looking into going to law school. I didn't bother with the MCAT. I took the LSAT instead. I got into law school in a couple places. So I picked one and I went there directly out of undergrad.
Oh, that's awesome. Yeah, because I saw that you, like you said, you majored in psychology and minor in criminal justice. So it seems like you're keeping your options open. Did you ever consider becoming a psychologist?
I did. I actually asked my parents what they thought about whether I go to seek a PhD in psychology or whether I go to law school. And they said, we'd love to see you do either one, but we think, from what we know of you, that you'd be a great lawyer. you, you've always had that mind of, looking at everything from a lot of angles and trying to make the best argument, no matter, what the situation was. You could flip and do one side or flip and do the other just for the sake of argument. So they said, I think that's your gig. We've seen that in you before, and it's interesting that you're asking us, what we think, because that's what we think. So
That's awesome. So you've always been somebody that looks at fact from a unique angle.
I try to, and I'm always asking questions. I feel like, and that comes in handy in bankruptcy practice. Um, I have my paralegal triage the potential client when they come into my office and go through everything with them. And lo and behold, when I get in there, probably 50% of the time, I elicit many more facts from them that they didn't even think to discuss that highly affect their case, actually. So it's the things that sometimes people don't think to ask or think about that are really important for practicing law.
That's awesome. So what led you to the practice of bankruptcy?
Yeah, it was kind of a circuitous route. It was me trying to find something that really tied into my overall goal of helping people, and having that feeling of helping. So it's kind of like when you fertilize your lawn versus when you cut your lawn, I think. Um, you can be in a practice where you have a case that you're working on for years and years, and maybe never see the result of. Whereas with what I do, it's like you cut the lawn, you see the result right afterwards. And so I always wanted kind of that feeling in my representation in cases. So I went about finding that through practicing personal injury first. Then I went on to criminal defense, domestic, and a little bit of estate planning, where I could really be in front of my clients and see what their situation was and maybe take a more holistic approach. I know you came in here for this, but I've identified this issue as well. Let's create these steps for success for you. And I really found that I could do that most successfully in bankruptcy. It's a unique practice area. You can't promise your domestic client that you're going to obtain the result they want, nor a criminal client. And you really can't promise that anywhere. But for the most part, when I tell my clients, follow these steps, take my advice, and your case should turn out this way, bearing any unknown factors, that's usually how it goes. So it's nice to be able to have kind of that comfort level of saying, this should be how it turns out, and not we have no idea what the other side is going to do. There are more difficult cases that you have to give many warnings, and there are a lot of unknowns. But for the bulk of cases in bankruptcy, as long as you have the facts right, you know how it's going to turn out, and it's always
That
going
is
to
ironic.
yeah, and it's always going to help your client. So it's a wonderful practice area to be in, for that feeling of I did something and this is how great it went for them, and look at the results of their life now.
So the bankruptcy practice is your banker when it comes to letting clients know what to expect.
Yes.
So you started off working for a law firm. So what inspired you to go out on your own? Because I know that has to take a lot of guts. Because
Yeah,
not every attorney is a business person.
that's right. And I can't pretend like that's my biggest strong suit. I like practicing law more than I like running the business. But I feel like sometimes when you get involved in a firm, the clients that they're bringing in aren't the type of clients that you necessarily want to handle. And sometimes you don't have those decisions that you're allowed to make. And so I decided that I wanted more control over my book of business, my clients, and who I was willing to help, versus who I felt should be referred to a different attorney. So for that reason, I started looking into it. And then the more that I thought about it, the more I thought, I do want to be an entrepreneur. I do want to, build something for myself and possibly my family, that I can have in the future. So there were a lot of reasons, but those were the two main ones. Is I wanted independence on a level that I wasn't able to have in a firm environment where I was.
Independence and building a legacy.
Yes.
Unique attributes. That's awesome. Can you tell us what does bankruptcy itself mean?
So bankruptcy itself is bancarrota, which is literally the words broken bank, and it came from a Latin term that meant, back when there were no forms of currency and it was a lot of barter and trade. If somebody had taken out too much trade credit, the lender would go to the town market wherever the person was, and they would break their table that they were using, or break their property and say, now you're not working anymore because you didn't pay me. So that's really where it came from. But now what it means is a fresh start. It's an opportunity to gain freedom from debt in a way that you cannot do by negotiation directly with your creditors. So it's something that it's of a tool that anyone can use, that's struggling with debt.
Okay. But how will someone know when they need to consider bankruptcy?
Well, that is a really good question, and often one that isn't thought of soon enough. Um, the clients that come in sooner than later because they never considered bankruptcy, but maybe have a different legal issue, and that attorney has identified, you know, this is getting in the way of what we're trying to do in this particular case. Why don't you go talk to this bankruptcy attorney, and maybe we can get rid of this issue here that's part of our case that can be resolved. And in doing so, a lot of times those issues are identified early, and sometimes we can keep the person out of bankruptcy by doing workouts instead. But sometimes it does make sense to plan for a bankruptcy as opposed to hurry up, file right now because there's a garnishment or your car is about to be repossessed or you're about to lose your home. Those are many cases that we see because the right time to file bankruptcy is whenever you do, but sooner than later if you feel like you're in a crunch. And it's really different for every individual situation. That's what's also fun and exhilarating about bankruptcy, is that every single case is going to be different because every single person's life situation is different.
Thank you. And what are the information that a person will need to gather before they start the process?
Yes, there's quite a bit of information actually, and that's sometimes the hardest part for debtors is getting those things together. And so at my firm, that's something that I really like about what I'm able to control, is that we are hands on. We hold people's hand to try to get the documents for them if they don't know how, and walk them through that process. But it's things like it's really, I guess, a financial um, lobotomy, if you will. You just put everything on the table. So anything related to finances, the bankruptcy attorney is going to need, such as income advices, pay stubs, child support statements, unemployment statements, retirement statements, social security statements. Those are all income related documents that we would need. Bank statements that show that flow of income in and the expenses out. I usually have my clients create a budget on their own, and then we talk about it later, along with an asset list of all the personal assets that they have, car titles, car insurance proof, tax returns for 2 to 3 years, depending on the type of debtor that you're working with. And then there's always something called credit counseling, which is a requirement that every debtor must complete before filing bankruptcy, unless it's a corporation.
Is bankruptcy something that a person can do on their own pro se?
Yes, there are pro se bankruptcy debtors. There are some successful ones, and I'm always very impressed with them. And as is the trustee in the court, because it is a very large and time consuming endeavor to figure that out on your own and then properly go through that process. Um, but for more times than not, the pro se debtors do not get all the way through the court process and they get dismissed, and then they have a bankruptcy on their record with no benefit. And it's not great to see that. And unfortunately, that is what happens in the majority of pro se cases. But it is completely legal. And the schedules encourage knowledge of debtors. So if anyone did want to try to do it on their own and spend weeks and weeks figuring it out, they could. But I would also encourage them to at least seek a consultation from an attorney. Many of us offer free consultations. And even if you tell us I want to try to do this on my own, my inclination would be to say, here's how you do it. Good luck, because I always want people to be successful, whether they're hiring me or not.
Is there a threshold amount that could be discharged in bankruptcy?
There's not a threshold amount that can be discharged, but depending on the case chapter, there is a limit on debt for Chapter 13. So if you're over the debt limit, you would have to seek a different chapter, like Chapter 11. There's a small business Chapter 11 that could be filed, or perhaps Chapter 7, depending on how the debt structure is structured as far as personal debt versus if there's business non-consumer debt.
Okay, now let's move on to the next chapter. What is the difference between Chapter 7, Chapter 11, and Chapter 13?
Sure. So Chapter 11, while it can be used for individuals, is generally a tool for businesses because there are so many more legal requirements on counsel before even filing the case. And then upon filing, there are many, many motions that must immediately be filed. Way more volume than a Chapter 7 or Chapter 13 as far as pleadings are concerned. So that means a lot more fees. And so that's really not a good plan for your typical individual. Most consumer individuals are going to seek Chapter 7 relief or Chapter 13 relief, which all in the end give the same result, which is a discharge as long as you complete the process properly. Chapter 7 is considered liquidation, which means that the assets of a debtor, if unexempt, will be liquidated to pay creditors. And then once the creditors are paid any assets out of the bankruptcy estate, the debt is then discharged and the creditors are enjoined from collecting. In Chapter 13, and it's filed for a various number of reasons. In fact, a lot of people who qualify for Chapter 7 choose to file Chapter 13 for certain strategic reasons, but it is a repayment plan. So instead of filing and generally paying nothing to your creditors and moving on, you file a plan about how and how much you'll repay your creditors before you move on free from debt. And those plans can last anywhere from 36 to 60 months typically.
Okay, but they have to be willing and able to pay those debt off within that amount of time.
Correct, but not always 100%. So a person could owe 50,000 and propose to pay 5,000 in a Chapter 13 plan, and as long as it was accepted and confirmed, that would be the plan, and that would be what they would pay, 5 out of the 50, and then they would receive their discharge.
Okay. Is it possible to have an hybrid filing of both personal and business bankruptcy?
Can you repeat that? I didn't understand.
I say, is it possible to have an hybrid filing where you want to discharge both personal and business debt at the same time?
Yes, I rarely file a case for a business and the owner individual. I've done it probably twice because businesses do not receive a discharge in Chapter 7 bankruptcy. So it doesn't make sense. They could in a Chapter 11, but I don't practice that. So in Chapter 7, the only reason that you're really filing bankruptcy for a business is to ensure that the owner of the business is not going to have blowback from creditors thinking that they stole or there's some sort of fishy thing going on with what happened with the business assets. Was there conversion? Did the debtor just take the business assets and move on? That's not their stuff. It's owned by the business. So when there's particularly a lot of assets, that's when you would look at a Chapter 7 bankruptcy for the business, just to make sure that the creditors can get their assets back and everything's on the up and up and on record with the court, and then nothing blows back on the business owner. The business owner themselves is going to list the business related debt in their personal bankruptcy case as a non-consumer debt, and that will be discharged as to that individual at the end of their case.
And what are those assets that are protected under bankruptcy?
It depends. There's several exemptions in bankruptcy, but the typical ones we're using are homestead exemptions. It's a little bit more than 143,000 per person right now, and that changes sometimes quarterly, sometimes less often. But each ownership interest is entitled to that exemption, so it's pretty high now. It's difficult to find somebody with enough equity in their home to really become an issue in bankruptcy. Although with the housing market the way it is, it's more likely than ever. There's a motor vehicle exemption right now that's $4,000 per person. So if you have a vehicle title in one person's name, that's a $4,000 exemption. If you have a jointly titled vehicle and both of those individuals are married and filing bankruptcy together, you could exempt $8,000 on that vehicle if you chose to do that. Cash on hand is pretty low; it's only $500 per person. Personal property is pretty high. You're not going to usually get there. It's think in excess of 12 or 13,000 now. We don't usually tap into that limit. So exemptions like that exist, but there are other exemptions that are a little bit less certain as to whether they apply. And those are things like life insurance, transfers, annuities, IRAs, ESOPs, and stock plans. So those are where the tricky exemptions come in and where you really need to get into your bankruptcy brain and figure out, can I protect this client's $13,000 account, or are they going to lose that in bankruptcy and we need to create another plan there?
Thank you. And in a situation where a client has a significant equity in their home, will the bankruptcy court force them to liquidate that equity?
Yeah, so on an asset issue, if there's enough equity, that's when you start looking at Chapter 13 because that repayment plan protects that equity. But if there's a reason to file Chapter 7 with somebody with non-exempt equity in a house or a car or anything, we do strategically do that sometimes. And then it is the debtor's option before anything does get sold and turned over that they can buy back that property by paying that equity. So that is typically what happens if you're planning on filing in that situation.
Okay. And bankruptcy law is federal and not local. Is that correct?
It's everything. It's a federal bankruptcy code, but in the code it brings in all of the state property law rights. So that is why bankruptcy is different in California than it is in New York, than it is in Florida or Ohio, because property law rights in all of those different states that I mentioned are completely different. So even though I'm federally licensed and I technically could file a bankruptcy case if I wanted to, and New York, as long as I went to the district there and got a federal license, I wouldn't do that because I don't know enough about those state property law rights. So it's really important to know both state law and federal law, but the code and the relief that's provided is under the federal court system.
Okay. And a client who wants to file, can they file in any jurisdiction or do they have to file in the jurisdiction where they reside?
Yes, venue does need to be proper. So the person needs to live in the venue for at least 91 days in order to qualify for relief there. And then the exemptions, again, are driven by state law. So at least in Ohio, sometimes it's federal, it depends on the state. But here in Ohio, they're driven by state law. So if the person has not lived here for a long enough period under 522 of the bankruptcy code, you do an analysis of where they lived the longest in the past certain period of time. It's usually about 2.5, 3 years that you look back, what property they owned, if they owned any real estate, and then you go through that analysis to determine what type of exemptions apply in that case.
And how long does the bankruptcy process take?
It depends. I have literally filed a case the same day that I met a client because he was ready to go. He just didn't like the counsel who had prepared his case before. So I went through all the necessary things, and 3 hours later, we were filing his case. And I have taken over a year or so to file cases sometimes for various reasons. Like I said, sometimes there's debtors that come to me and it's not necessary to file bankruptcy at a time, but we know it's coming and we're just um, trying to protect them with proper advice until we, perhaps get there. So it doesn't have a timeline. I always tell my clients the timeline for filing is usually up to you. And if there's anything going on in my office that you need to know about that might affect it, I'll let you know. But that's not usually the case. The timeline after filing is usually what's more certain because that's kind of statutory as far as how long notice periods last and how long a plan can last.
Thank you. Is there a downside for filing for bankruptcy?
Um, Less, I think, than the stigma out there implies. So there are sometimes downsides. Sometimes you do lose property, and as long as you know that that's going to happen, and you feel like that, slight downside is outweighed by all of the benefits, then properly proceeding is fine. But I don't see a lot of downsides, and I think it's because I'm on the side of helping people file bankruptcy. And I've never had somebody come back to me and say, I wish I would have never filed that bankruptcy case. Now, sometimes they say I shouldn't have reaffirmed on my car, or I wish I would have, done this differently in my case. But that's sometimes things that it's hindsight, it's 2020, we wouldn't have known. For example, I had a client once that really did not want to file bankruptcy. And he only had two debts, and one of them was a foreclosing mortgage and the other one was a credit card. And aside from the fact that the mortgage was foreclosing, he probably would have never had to file, but there was a sale date and it had been kicked enough times that they weren't going to do that again. He needed to file to save his house and get the stay. Um, so the plan was basically we have to pay off 100% of the credit card because we can afford it. We're going to catch up the mortgage and then we're going to be done. Well, the credit card, it was a high balance. It didn't file. So he was in and out of his bankruptcy in less than a year because he paid off 100% of all claims filed in the requirements under the plan. So he didn't love it, but at the end he did. So it always depends on the situation.
So, how do you help clients to deal with the stigma attached to filing for bankruptcy? How do you counsel them?
As far as can you repeat that question?
This the societal stigma attached to filing for bankruptcy. How do you help client to navigate that stigma?
Well, I always remind clients that it's very hard for anyone to discover that you filed bankruptcy unless you're a very large political figure or you have a lot of assets that it would be newsworthy. No one's publishing a bankruptcy in the Columbus Dispatch unless it's, again, so and so person. Like if Mike DeWine filed bankruptcy, I'm sure we would all know about that. But if your neighbor files, you're likely not going to know about that. The only time that it can be found is by someone with a Pacer login, and that they're willing to pay for the search and have your social security number, or can fish your name out of a list of however many John Smiths have filed bankruptcy in the past year. So it's really got to be somebody who's looking and searching for you. Otherwise, it's your disclosure as to whether you want to share that you filed with anyone.
Okay. So bankruptcy is not public knowledge, not public record.
It is public record. Like I said, people can find it. It's just under the federal PACER system, which requires a login and it requires a fee to access. So most people, most general people, don't look for that.
Thank you. And how does bankruptcy affect the filer's credit?
Usually it helps, which is the point, right? Bankruptcy is supposed to be a fresh start for your credit to help you. If bankruptcy was meant to just be another thing that brings you down, I think many people would not file that. But it does affect your credit in ways that are difficult to tell sometimes because, again, each situation is different and the credit scores are proprietary. So Experian, Equifax, and TransUnion all have their own formulas, which is why you have three different scores if you look them all up, as to what your credit score is. But mainly it's composed of your debt to credit ratio. So generally, by the time that somebody is filing bankruptcy, their debt to credit ratio is shot. They may be over the debt to credit that they have, or they may be right around, fully tapped out where they can't borrow anymore, and that hurts them. So it's better to have no credit reporting than credit that's over the limit. So it would actually be a boon to file in that situation. Um, it does hurt your life of credit because your accounts close and your credit life is something that is factored into the score. How much, we don't know. But you have to think of it, I think, from a creditor perspective to think about how bankruptcy is going to affect your credit. If you're going to lend your neighbor money and you look at the credit report and you see that they owe in total $98,000 in unsecured debt and they're asking to borrow $5,000 from you and pay back $200 a month, and you see how much they're paying out on their credit report and how much they owe, you're going to think they're a pretty big risk. And you might want to charge them a really high interest rate because you know that they may not pay you back in full on the principal of the loan. So that's the same thing creditors are doing. So getting rid of all of that debt that shows, hey, I'm a risk, I may not be able to pay this back, is going to be helpful to a debtor.
Thank you. So it's all about solvency versus insolvency.
Mhm.
Okay. So how can someone who filed for bankruptcy rebuild their credit?
Yeah. So if you file for bankruptcy, when you want to rebuild your credit, I usually make sure that my clients have a good, clean line in the sand where the account that they're starting in order to rebuild credit is far after the bankruptcy. So I usually say, get your discharge order, wait a month or two, and then apply for credit. But you really only need one credit card. You don't need a bunch of accounts, and you certainly don't need a store account like a Kohl's or a Target that doesn't. They report to your credit report, but they can't be used everywhere, so they don't work as well for score building purposes as a card that you can use at the gas station, the grocery store, and everywhere else. But I also caution them to make sure that they have a savings account built before they start borrowing credit. Sometimes we have the best intentions on using our credit card to charge 250, and then find that we can't pay it all. And so if you have a savings backup in case your payment plan kind of got, you know, in a situation where you thought that you could pay the minimum payment or X amount and you can't, you now have savings that you can apply to that. So I always want people to have savings, at least in the amount of anything that they charge each month, before they go and use it, because you don't want to have late payments or a lot of credit built up shortly after bankruptcy that will really affect your score. Another thing I recommend is when you do get that credit card and you get your first statement, make sure you set yourself up on at least automatic payments for the minimum payment per month. That will prevent any late fees or charges hitting your credit. So sometimes we just forget. We weren't, especially after bankruptcy, in the routine of paying our credit card again. So if something happens and you forgot and the due date was 2 days ago, it might show up as a late payment now, and that's a delinquent payment after bankruptcy, and that's really going to hurt. So I always tell people just set up the minimum payment as an auto pay, and then of course pay the rest. I always want people to pay off the credit card balance when the statement comes, but I'd rather, if that was forgotten or if it's just not possible, that they at least have the minimum payment to comply with the terms of the credit card.
Can mortgage or car note be discharged in bankruptcy?
A mortgage and a car note are both dischargeable by default. So if a person files bankruptcy in Chapter 7, the default is that it will be discharged unless they request and the creditor agrees and the court approves a reaffirmation agreement.
And what is a reaffirmation agreement?
It's essentially a novation of the original contract where the debtor is saying, I had this contract, bankruptcy discharges it, but I don't want that to happen. The creditor and I agree that it's not going to be discharged. We sign this in writing before the discharge and we file it with the court. And as long as the court agrees that that's fine, then it's on the record and it's reaffirmed. There is a rescission period of 60 days. So if the debtor changes their mind, they can rescind the agreement. But otherwise, it becomes permanent, and it's as if they never filed bankruptcy as to that account.
Okay. So if the creditor appears in court to defend the property, so it's highly likely that the mortgage or the car note will not be discharged.
No, the creditor generally cannot seek non-dischargeability of a car note or a mortgage that is automatically discharged unless there's some sort of fraud. And in that situation, they would have to file a separate adversary proceeding to determine whether they can prove that the debt should be non-dischargeable.
Okay. When someone files for bankruptcy, can the loan company come to repossess the car while bankruptcy is still pending?
No, not unless they've received relief from stay. So there are many cases where the debtor files bankruptcy intending to surrender the car back to their lender. But that does not give the lender the right to just go get it, even though the debtor has indicated, I want to give this back to you. They have to file what's called a motion for relief from the automatic stay that comes into place as soon as the case is filed. And they basically plead to the court, look, this debtor has already said on the record they don't want this vehicle. We haven't received payments. We need to collect our collateral to reduce any damages that we have from the non-payment and the surrendered vehicle. And there's a notice period of about 21 days, and then the creditor can then come repossess the car.
Okay. Can student loan be discharged in bankruptcy?
The default is no. So just like the default is yes for car notes and mortgages, it's the opposite for student loans. So 523A8 says no, unless there is an undue hardship. So you would think that would be easy, right? I have an undue hardship. I can't pay my loans. But in our district, which is the Sixth Circuit, we are bound by the Bruner standard, which is a 3-part test. And through the process of case law and judicial decision, it's very difficult, if not impossible, for a student loan to be discharged in our district because of that high standard that we call the Bruner test.
Okay. For a lot of people watching this, most of them are non-attorneys. Can you break down what the Bruner test is?
Sure. There's 3 factors. Essentially, it breaks down into having the inability to pay for a sustained or long period of time that's into the foreseeable future. So basically, you can't pay forever for the rest of your life. You also have to show that you had in the past a good faith effort to make payments to that loan. So if you've never paid back a student loan, it's going to be really hard to show good faith. And there are actually, surprisingly, a lot of student loan debtors who have never made a payment, or very, very few. And so that standard is difficult as well. And so the undue hardship plus, and there's 3 factors, but those are the main ones that you must prove. And it's very difficult. I've seen cases in our district with judges that, say, well, this person can pay $10 a month. So that's something. So that counts. So if they can pay something, then they shouldn't be discharged. And so here's your $250,000 loan balance back. Good luck with that on paying $10 a month. And it really creates a certainty of hopelessness, unfortunately, for a lot of debtors that have massive student loan debt and the income that's never going to cover that balance.
How about student loan debt from a private lender?
So that's debatable. So there's been recent case law that's come out in other circuits that have been hopeful. I don't think anyone's tested it in the sixth yet. But some private student loans have been discharged based on the standard that the amount borrowed for that loan was in excess of what was needed for educational purposes. So that's a fact-driven, intensive discovery issue that a council would have to go through in order to determine that. So I'm not going to say it's impossible, but I don't see anyone picking up that bat and trying to hit that one out of the park here yet.
Are outstanding HOA fees dischargeable in bankruptcy?
Also something that you're not sure of. It depends. Is the person keeping the property or are they surrendering the property? Are the HOA fees being charged before or after the bankruptcy? Does the HOA contract run with the land, meaning it's attached to the land or not? So without knowing all those factors, I wouldn't be able to tell you, but those are the factors we look at to tell the debtor, we can discharge these or we're going to have to deal with these in some way. But generally, any HO fees due prior to bankruptcy filing are at least dischargeable personally as to the debtor. They may still remain on the property.
Hmm, okay. Yeah, you were a cheerleader in college.
Yes, I was.
Is
All my
that
life,
it?
really, through college.
Really? What was that like?
Yeah, I think I, at 5 years old, went with my brother to the Pee Wee football sign up, and they had a little table there. Hey, does anyone want to be on the pep squad? And my mom said, well, she's coming to all the games anyway. Put her on the pep squad, and then I can sit quietly and watch the game, and she can sit over there with all her friends. So that's how I got into it. But I just really excelled at it. I loved it. I liked the camaraderie and the friends. But it got a little difficult in high school. It was a lot. So I didn't seek to do cheerleading again. I just wanted to go to college and work hard and study hard so I could be a lawyer or doctor. But as fate would have it, I showed up to my dorm in freshman year of college, and my roommate was like, "Hey, I'm gonna go try out for the cheerleading squad. Didn't you say you cheered? Let's go. Let's do this together." And I said, "No, I'm not doing. I know I'm not doing that. Why would I do that?" And she's like, "We'll just walk right on it. It'll be fine. Let's just do it." And so we walked into the gym and met some cool people, and that was history. And then we were cheerleaders. I think she quit at the end of college, but I went all the way through my 4 years in Xavier University cheering for the Musketeers men's basketball team, and they made it to the Elite Eight that year. So we had a great time, and it was a really good group of friends to hang out with. It kept me in shape and busy, so it was great.
And here you are, still cheerleading people to freedom from debt.
That's right, exactly. I'm their biggest cheerleader.
Exactly. Is your daughter, does your daughter do cheerleading too?
No, they really didn't take to anything that I thought. Like you think I'm gonna have kids and they're gonna do the things that I like to do.
I
Actually,
know.
one of them does, but my oldest does ice skating. She's really good at it. I love watching her do that. And then my middle child does equestrian, so she loves riding horses. I did that growing up, but it wasn't um, regimented. It was me going out on the trail and hanging out with the horses. And I did some barrel racing and stuff, but she has like these technique things and this horsemanship and all of these, I don't know, terms that I don't understand. And it just looks like she's riding a horse to me, but it's it's
She's
something that she
more
really
advanced.
enjoys. So yeah, and I think my little 2.5-year-old is going to be a PGA golfer someday because he swings the club like a pro. He loves it. He always wants to go hit ball. So
Wow.
yeah, those are their sports right now.
Born golfer. And you also belong to the board of your community swim team.
What's that? Which team?
I say you also belong to the board of your community swim team.
Oh yes.
So are you a swimmer or do you swim competitively?
No, I never swam, and in fact, I don't really know how to swim very well. I couldn't do laps, I promise you. But my daughter, my oldest, we live right across the street from the community pool, essentially, and so her girlfriend in the neighborhood wanted to be able to ride a bike with somebody to practice, and it was just a fun summer swim league. So she got into it and loved it. And then it's a full volunteer driven team. There's no one that's paid to do Dublin Dolphins. So they're always looking for people to help. And without knowing it, I took a position that was an apparel coordinator that happened to be a board position. So it was a little more than I expected. But I did that for 3 years, I think, 2 or 3 years. And I just recently stepped down because I'm running a campaign for election for judge. And that just, I didn't think it was fair to them or my family to stay on with that I wouldn't have time to dedicate to that.
Okay, so let's move to your candidacy chapter.
Yeah.
So, what inspired you to seek this office?
Yeah. So if people are just logging on, they don't know what we have been talking about, but it's really that heart of helpfulness to others that inspired me to look into it. I never considered running for any type of elected position because I really am more of a private person. I don't like to, put myself out there in the public spotlight a lot. Um, but for this endeavor, I felt that it was worth it because it's Franklin County Municipal Court, which is where I started my practice when I started my first firm on my own before being absorbed into another firm. And I really like the understanding that I have and the respect that I have for the court and the professionals that work there and the people that come through there. So it's really the people's court. It's it's kind of like that, I feel like mowing the lawn position where when you're adjudicating cases and controversies in municipal court, you can see the decisions that you make either improve lives or help public safety. And I think that those are really important things for the community to have somebody that understands the people that are coming before them, and that what's necessary in order to enact justice in each situation is different and needs to be looked at on a fact and case by case basis.
Thank you. You have this theme in your, let me say, academic career slash professional career where you are cheering people to either victory or encouraging them, or in your practice, cheering them to financial freedom or to be debt free. How do you translate that to the bench?
Yeah, so the bench is more of a neutral position, and in fact, it's required that you're impartial. But I think that you can cheer others on in a way that you're encouraging them to do what they are able to do best. So whether it's the prosecutor making a good argument, or the defense attorney, or whether it's a plaintiff that's been aggrieved, the way that you treat them positively instead of negatively is really important to their uh, I think their sense of justice at the end of the day, regardless of the case result. It's always really important to be that cheerful, positive person that's saying, this is a bad situation, and this is going to be something that hurts. You're not going to want to go to jail, but this is going to help you in the long run. So just trying to put everything in a positive light and make sure that the people that you're making decisions for understand at least where you're coming from and why you've reached that decision, and that it's not anything that's out of any type of malice or um, any type of political reason, but really just because you feel like this is the best thing that's going to help everyone. And I think that's the way that you can cheer on the system towards justice.
Thank you. And apart from your educational and professional background, what makes you uniquely qualified to become a judge of that court?
Yeah. I really think it's an unteachable trait and quality that I have, which is compassion, understanding, and that sense of gut feeling of what the truth is. I don't think that justice is possible without truth. And while it's easy for people to get confused and not know what the truth is, I always feel like I have that beacon of clarity that after having an open mind, and maybe that's the trick, to listening and hearing things out, you come to a conclusion that you feel is right. And so I don't think that's teachable. You can know the law, you can know the code, you can know the sentencing guidelines, but having that beacon of truth and understanding is really, I think, what sets me apart and will make me a good judge on the bench.
Thank you. And what has it been like running a practice concurrently with running for office?
Sometimes I don't know what day it is. My weekends have turned into weekdays, which I always promised myself I wouldn't do. I always reserve the weekends for my family. And that's why when I ran, I talked to them and made sure that, you know, they understood that it was only going to be a temporary thing. This is not going to last forever. And weekends, we'll go back to weekends and family time. But right now, it's a sacrifice. It's a sacrifice, like I said earlier, of cases that I'm not taking because I'm not sure what the future holds and I don't want to commit to something that I can't finish. It's a sacrifice of time, a lot of time. Sometimes I feel like I need three of me. And but overall it's worth it because in the end, regardless of what happens, I feel like I've moved justice forward by creating a good race and putting a good foot forward for people seeking the bench. And of course, if I am fortunate enough to take the bench, to continue that.
Thank you. And what are those new things that you've learned on the campaign trail?
Oh, I've learned so much. And really, it's about meeting people because that's what you do when you campaign. You go to these different community groups and events and try to, you know, get your name out there to as many people about what your cause is, what you're doing, what you're, you know, running for, and what makes them tick. And I've met so many wonderful people. That's been something that while it seems obvious what happened while campaigning, I just didn't understand the volume of how many great people are out there trying to help good people get elected. So that's been great.
Thank you. And how can people reach you?
Oh, yes, thank you. So I have a website for my law firm. If you're looking for bankruptcy assistance or advice, it's www.thenesbittlawfirm.com or nesbittfirm.com. Or you could go to laurahelps.com. Those are all things that will lead you to my website. If you're looking for campaign information, you can go to www.nesbitt4judge.com, and that's the number four. So my last name, the number four, judge.com.
Thank you very much for coming on the show. It's been a wonderful time talking to you.
Thank you so much for having me. It's been good to talk to you as well.
Thank you. And for those of you watching us at home or listening to this podcast, thank you for tuning in. Until next time, stay blessed.